However, during the period of his tenure as a judge in the Eastern Caribbean, Justice Saunders was deeply involved in judicial education and judicial reform issues. He chaired the committee established to introduce court-connected mediation in the Eastern Caribbean. As chairman of the Ethics Committee of the Eastern Caribbean Supreme Court, he presided over the production of a code of ethics for the judges of the Eastern Caribbean. He also served as chairman of the Judicial Education Institute of the Eastern Caribbean Supreme Court from 2001 to 2004. He regularly participated in judicial education programs for judges throughout the Commonwealth as a faculty member of the Halifax-based Commonwealth Judicial Education Institute. Mr. Justice Saunders is currently the chairman of the Caribbean Association of Judicial Officers. He has also written and published several legal articles and contributed to publications. As a former Acting Chief Justice of the Eastern Caribbean Supreme Court, he also served as the chairman of the Judicial Education Institute of that court. He played a leading role in collaborating with the Justice Project, CAJO, and UN Women in developing and promoting the adoption of gender-sensitive protocols for various Caribbean judiciaries. He is the contributing editor of the Caribbean Civil Court Practice, essential guide to the civil procedure rules as they apply in the Caribbean. He co-authored Fundamentals of Caribbean Constitutional Law, a resource for students, legal practitioners, and judges of Caribbean public law that articulates, discusses, and clarifies fundamental principles of constitutional law in the region. He championed judicial education throughout his judicial career, with specialized expertise and experience as a judicial educator. He has developed several programs, including as a course director of the CCJ's Intensive Study Program for the Commonwealth Judicial Educators. In addition, he serves on this board which provides support for the creation and strengthening of national judicial education bodies, encouraging regional and pan-Commonwealth networking, the exchange of human and material resources, training judicial education faculty, developing programs and modules to be used in all Commonwealth countries, and designing judicial education programs. Dr. the Honorable Mr. Justice Adrian Saunders, son of the Vincentian soil. We are indeed very proud of him, as he's now seated as the President of the Caribbean Court of Justice. Justice Saunders.
Thank you very much, Renee, and pleasant good evening to all. I will go through the protocol list as has been done by my old schoolmate, Mark, and I went to school together. One of the things about coming to New York and coming to a function like this is that you reconnect with so many old friends, and it takes you back to growing up, going to school, because many of you who have seen here tonight, who have not seen for a long time, look back so much of my school days. I'm really very pleased to be here to deliver this lecture. Before I actually get into the lecture, I would like to express my condolences to Cheryl and to the entire diaspora here in New York. With the anniversary of Maxwell's passing. You know, I was going through my emails earlier this week, And there were just hundreds of email messages over the years from Maxwell. And I looked at one in particular, which was a press release where he was speaking about the 2016 launch of the Heritage Awards, where he and his committee recognized the service of several Vincentians who have contributed to the building up of the country of St. Vincent and Grenadines. All too often we take for granted a lot of the progress that we've made. We benefit from a lot of institutional advantages, and we never seem to recall or give much thought to the notion that a lot of what we take for granted, a lot of what we benefit from, is built on the sweat of those who have toiled for us. And so it is always good to recognize people who have made a contribution. And Maxwell and his committee did not forget to do that and launched that very significant Heritage Awards celebration 2 years ago. I remember coming to a meeting at the UN maybe 5 or 6 years ago, and we connected with Maxwell. He saw me, and we went to lunch together. I think the last time I'd seen him, and it was a special occasion because there was much to catch up on. As you have heard, I assumed the presidency of the Caribbean Court of Justice in July of this year. That was the culmination of a journey that, in a sense, began in 1996 when I first took up judicial appointment. I was posted then, in 96, to Little Island of Montserrat. At the time, it had an exploding volcano. But I figured that I'd gone through that already in 1979. But at the time I took up that appointment, I was still relatively young to be appointed as a judge. Most of my colleagues on that court were in their mid to late 50s. I had just turned, I was just 41. And I remember that very first week in Montserrat. On my first day on the job, an impressive police guard of honor was assembled for me to inspect. So here am I, decked out in my judge's robe, escorted by the commanding officer, who is waving about a sword. And I'm walking between these neat rows of ramrod-trained police officers with stiff, starched tunics and shiny black shoes. And there's a huge crowd of people curiously looking on as the police band plays a marching song. And frankly, I'm a little bemused. I'm trying very, very hard to put on my best judge face. And then this market woman said I was pretty young, I had no gray hair, a baby face. This market woman in the crowd takes one look at me and says, "But where you going with that young boy there?" The commanding officer scowls at the lady while I'm trying my best to suppress laughter. But it's one of the things that I think has served me in good stead over the years as a judge on the bench. Try not to take yourself too seriously. At the end of the day, it's important to see the human side of things. As for the CCJ itself, and the gist of my lecture this evening, like to see the CCJ, the Caribbean Court of Justice, as another milestone along the path that we take in determining our own destiny. And I want to use that imagery in relation to St. Vincent and the Grenadines. When I look back on our country of St. Vincent and the Grenadines, particular years and events jump out at me. For example, the year 1498. The significance of that year in our country's history, in a very strange way, goes back to Portugal. The patron saint of Lisbon is a certain gentleman called Vincent of Saragossa. Vincent was tortured and murdered in the year 304 because he refused to burn a Bible. The Catholic Church later made Vincent a saint, and Portugal celebrates St. Vincent's Day on January 22nd. Now, my generation was taught that Christopher Columbus sighted St. Vincent on the 22nd of January, 1498. And that when he saw the island, because of the date, he named it after St. Vincent of Saragossa. Well, that story sounds very cute, but as a certain gentleman loves to say, it's fake news. And the late Peggy Griffith spent a lot of time and effort pointing out that it was indeed fake news. But officialdom did not take on Mr. Griffith at the time. Up until not so long ago, we used to proudly celebrate what we call Discovery Day on 22nd of January. The fact is, of course, that on the 22nd of January 1498, Mr. Columbus was in Spain trying to put together men and materials for his third voyage. But we put all of that behind us. Our country of Iru, Zulu, St. Vincent was indeed discovered by Europeans at some time and was indeed renamed by them St. Vincent. How and when and why, I don't know. The next year I think of, as I look back, is the year 1763. Now, between 1498, when the Garifuna discovered Columbus and the Europeans, and 1763, the English and the French tried to colonize the country. During this period, everywhere else in the Caribbean, the name of the game was sugar and slavery. And these European powers were eager to get in on that action in St. Vincent and Grenadines as well. After all, our soil is very fertile because we have a volcano. But the brave Garifuna, or Caribs, who inhabited the island, would not allow these Europeans to settle. See, they skillfully played the French off against the English. And in the meantime, they fought and resisted with all their might to safeguard the country from foreign conquest, so that neither of these two mighty European powers could have their settlers gain a firm foothold. Well, in 1763, France pretended to give up. At the end of a 7-year war with England, France signed a treaty in which, among other possessions throughout the world, it ceded St. Vincent to England. Now, the idea that you could give away what you never owned is, of course, laughable, but that's what the French did. The next defining year that I have in mind is 1796. Between 1763 and 1796, England, which had been ceded the country by France, they tried very hard to colonize the island, to subjugate the Garifuna, to establish sugar plantations. And they had several wars with the Garifuna. But again, Garifuna, with sly assistance from the French, they used to chase away the British settlers. But the British kept sending in more and more troops armed to the teeth. And in 1796, superior arms won the day. So in March of that year, our beloved and first national hero, Paramount Chief Joseph Chatoyer, was killed defending the homeland against the British. Now, an English historian named Charles Shepherd says that Chatoyer died in a duel with the English Major Leaf. That again is fake news. I prefer the version of events from a Vincentian historian, Dr. Adrian Fraser, who meticulously researched this thing and discovered that on the 9th of March the 14th, well, it's actually between 1763 and 1796, the English began building Fort Charlotte and began fortifying the country. If you notice at Fort Charlotte, a lot of the guns are turned inward and not to sea, and that is because they were preparing for battle with the Garifuna. So on the 9th of March the 14th, 1796, 2 battalions of English soldiers, they marched on Dorsetshire Hill in the dead of night, and they had a firefight with the Garifuna, where Chatoyer had set up base, and Chatoyer was among those who killed. With Chatoyer's death, the resistance was over. They rounded up thousands of Garifuna, put them on Baliso, and then from Baliso, took them to Central America. Britain now had relatively free reign over St. Vincent. It lost no time to get in the game, sugar and slavery. Garifuna culture lives on mostly in the names of places like Bayaboo and Leyu and Raraku, and of course in our love of farine and yam. French culture still remains in names like Barley, Connery, and Belair, Chateaubelair. And after 1796, the inhabitants of the island were made to speak English. English now prevailed, and our towns and villages were given names like Georgetown, Kingstown, Edinburgh, Bridgetown. And if there were disputes that could not be settled legally, locally, there were legal disputes that could not be settled locally, we sent petitions to England for Her Majesty's Privy Council to decide. Mercifully, slavery was abolished in 1854, although economic and political power remained, of course, firmly in the hands of English planter class. And in 1951, we got adult suffrage. That year, all Vincentians over the age of 21 granted the right to vote for representatives in the Legislative Assembly. So we began to produce our own political leaders, persons like George Charles and Ebenezer Joshua, Ivy Joshua, later Robert Milton Cato, under whose leadership our country became first an associated state in 1969, and then in 1979, an independent nation with the proud name of St. Vincent and Grenadines. Interestingly, in 1979, there were people in St. Vincent and the Grenadines who were uncomfortable with the country becoming independent. They wanted us to remain ruled by Britain. But not everyone thought like this. Most of us thought that Vincentians, as a proud people, must take responsibility for our own destiny. And so ever since 1979, we have struggled along for these last 39 years, seeking to build our sovereignty and to consolidate our independence. Now, what does independence mean? Well, first of all, we have to be realistic. Our country is a small one. It's poor, lacks natural resources, has a very small population. Although our anthem and our flag and our membership of the United Nations allow us to take our place in that august body as one of the nations of the world, the reality is that we are a really very, very tiny country. Independence presents us with severe challenges, but it also offers us possibilities for self-advancement. Independence has meant that we now take for granted that it is our own government which we elect ourselves, and not the Foreign Office of the United Kingdom that must administer the annual budget of millions of our taxpayers' dollars. We rightly expect that it is the representatives that we put into Parliament who must make laws to keep us safe and to propel the society forward. I don't think any right-thinking person yearns for a return to Crown Colony government, where all of these kinds of decisions were made in London without our consent and too often at variance with our own wishes and expectations. Today we take for granted the fact that we should govern ourselves, that we should make our own laws. You know, not many people appreciate it, not many people recognize it, but little Dominica, in 1978, went even further. They went further than any other country in the English-speaking Caribbean when they became independent. Because Dominica determined that on its independence, it was not going to be a monarchy. It was not going to have its officials swear allegiance to a queen who resided in England and who was English. Dominica's political leaders decided upon independence, the only English-speaking country in the Caribbean to do this, to make their independence even more real. They became the Commonwealth of Dominica with their own elected head of state. And as much as we all have the greatest respect for Queen Elizabeth II, I don't know that any Dominican now wishes to abandon their own head of state and return to a contrived situation where an English monarch is the head of state of Dominica. I doubt it. Did the heavens collapse in Dominica because that country chose to become a republic upon attaining independence? Of course not. Did Dominica suffer any adverse consequences? Britain put any embargo on them? Of course not. So independence requires us to think creatively. And because of our small size, it forces us to think regionally and to wield a foreign policy that yields the greatest possible advantages to us. In particular, we must make common cause with our Caribbean neighbors, because there are some areas of life where they, like us, need help. And only if we work together can we discharge all the responsibilities that independence thrusts upon us. So we have done this, first of all, in the OECS by establishing the OECS, the Organization of Eastern Caribbean States. share a range of services with the other OECS states. Most of these are, of course, a common currency. Can you imagine if St. Vincent had to have its own dollar, Grenada had to have its own dollar, St. Lucia had to have its own dollar? No, that just wouldn't make sense. So through the OECS, we share one central bank, we share one monetary policy. We have the same Chief Justice. There is one court throughout the OECS. There's one judicial system. Beyond the OECS, we are also members of CARICOM, Caribbean Community, and all its institutions. These include Caribbean Examinations Council, Caribbean Development Bank, and the University of West Indies, to name a few. These institutions help us to consolidate our independence from Britain. When I went to school, when I went to secondary school, we sat O-levels and A-levels examinations. These were set and marked in England, in Cambridge, or in London. The examination papers were sent off to England along with thousands of pounds sterling each year. Today, thanks to the Caribbean Examinations Council and to CAPE, Caribbean Associate Proficiency Examinations, our school children no longer sit those external examinations. They sit Caribbean examinations. And they are just as well educated as they were in my time. Questions that they have to answer are more relevant to their education, and the examination fees remain in the Caribbean. I remember, when I started Common Entrance, they had a question on we used to do 3 papers: intelligence, English, and arithmetic. And there was a paper on the intelligence, there's a question on the intelligence paper. Red is to stop, as green is to blank. This was in 1960. Red is to stop, as green is to blank. No? We didn't have traffic lights. But that was what was on the intelligence paper. So if you put black, you guess that you put orange. Somebody in England will say, boy, those people dunce. Before 1975, and all of this is relevant to the Caribbean Code of Justice, I didn't bring the wrong speech, or the right speech. Before 1975, there were no lawyers trained in the Caribbean. Thanks to University of West Indies, before 1948, there were no doctors trained in the Caribbean. Thanks to the University of West Indies, we've been graduated doctors, lawyers, engineers, accountants, dentists, you name it. And those professionals are just as good, very good ones, are just as good as the very good ones in England. The mediocre ones are just as mediocre as the mediocre ones in England. The ones that are not so good are just as poor as the ones that are not so good in England. Because the Almighty distributes brains randomly. They don't distribute brains to white people in England and then distribute a little bit less for black people in the Caribbean. We all have the same brains. And as long as we apply those brains, then we can utilize them in the service of our fellow human beings. So, all of these things, CXC and the CAPE, University of West Indies, and the OECS, CARICOM, all of these measures help to consolidate our independence. They make us more self-reliant. They help us to do for ourselves what we should be doing for ourselves. Now, a major step forward in self-reliance came when CARICOM established the Caribbean Court of Justice in 2005. The CCJ is two courts in one. It is a CARICOM treaty court, like the European Court of Justice, and is also a final court of appeal, like the US Supreme Court, or like the British Privy Council. So let us first speak about it as a CARICOM treaty court. As you might know, the CARICOM countries have made a pact, a treaty. They have agreed to establish a single market and economy where they encourage the free movement of goods, services, labor, and capital among the countries that make up the Caribbean community. So think of the treaty as a kind of constitution each country must abide by. The CCJ is the court one can turn to when any Caribbean country violates that constitution. The CCJ resolves disputes between Caribbean states that arise under the treaty. Because each state has its own peculiar interests, its own priorities, its own challenges, its own aspirations, its own goals. Strained relations among states are just as prevalent as those among people. Just a few months ago, Prime Minister Gonzalez had occasion to complain about the fact that our traffickers who would sell their yam and dashi and hello and so on in Trinidad, when they sold it, when they sold these products, they got paid in Trinidad dollars. And when they went to Trinidad Central Bank to get either EC dollars or US dollars so that they can spend that money in St. Vincent and the Grenadines, they were met with, well, we have a foreign exchange crunch, so you can't get foreign exchange for us. And of course, that's a problem between the two states, because if we export it to your country, then we expect to get real money, not money that you can't spend. Because if you took Trinidad dollars to St. Vincent, you can't spend that money there. So these are the kinds of strains and little controversies that sometimes arise among CARICOM states that require dispute resolution. Let us look at some other bases for some of these tensions. Country of Barbados. Relatively speaking, Barbados has a densely populated country. And that density is exacerbated by the fact that here it has 1 million plus tourists who visit annually. So all of these people place pressures on its limited social infrastructure and amenities. But because up until recently, Barbados had a fairly stable economy, Barbados is a country that is targeted by a lot of Caribbean people who seek a better life. So one result of this is that Barbadian immigration officials can be very zealous in protecting their country's borders. Look at a country like Jamaica, the biggest island. Jamaica also has the largest population size. Now, Jamaicans are enterprising people, but their economy is not doing as well as it was when they chose to separate themselves from the West Indies Federation. So some Jamaicans now find such great difficulty finding jobs at home that they're on the move, fully prepared to explore whatever opportunities might exist in other countries. Trinidad and Tobago, well, that's a country that has been blessed with abundant energy supplies, and that bounty has allowed Trinidad and Tobago to overtake Jamaica in light manufacturing. So Trinidad is keen to ensure that its manufactured products penetrate the region in preference to comparable products from extra-regional sources. Of course, the not so well-off states in the region would like to purchase cheap goods and not necessarily those manufactured by a sister CARICOM state. So these are the kinds of realities that make for stresses and tensions. Every community must endure these kinds of stresses. Their existence doesn't mean that CARICOM does not or cannot work. What it means is that there must be give and take. And so, in any community, what is critical is that you have a mechanism for resolving strains and stresses and the tensions. And that mechanism is the Caribbean Court of Justice. When a state or an individual feels unfairly disadvantaged because a sister state is not playing by the rules, then complaint can be made to the CCJ, and CCJ is authorized to provide appropriate redress. And so we have had cases where a young lady from Jamaica trying to vacation in Barbados, stopped at the airport by zealous Barbadian immigration officials, and is treated very badly, detained, put in a cell, reported the next day. And she complains to the CCJ that this is not how CARICOM is supposed to work. And she wins. The CCJ orders Barbados to compensate her to the tune of some 75,000 US dollars. And they pay the money. So that the court is not just a toothless tiger. Governments of the region obey the judgments of the CCJ. In another case from Guyana, Guyana has a tax on bottles that are imported into Guyana because they say they create plastic bottles, environmental hazard. But they don't impose that tax on Guyanese companies that are bottle manufacturers that sell drinks in bottles. And this Surinamese company, Suriname is also a member of CARICOM, the Surinamese company says to Guyana, well, the CARICOM treaty does not allow you to tax my bottles and not tax your own bottles. So you have been collecting tax from me for the last 7 years, and I am now reclaiming the taxes that I have paid over those years. Taxes amounted to several $1 million. And that's the complaint that the Surinamese company brought before the CCJ against Guyana. And they succeeded, because Guyana did not have a defense. One of the fundamental tenets of CARICOM Treaty is that there must be no discrimination on the grounds of nationality. So that you can't put a tax on a Surinamese company, or the products of a Surinamese company, and not put the same tax on your own, or the products of your own company. So this is the way in which the CCJ has been operating in what is called the original jurisdiction. That is, the jurisdiction where we deal with the CARICOM Treaty. The second role that I should mention that every CARICOM country is a member of the CCJ, so far as that role is concerned. Because once you belong to CARICOM, then naturally you are susceptible to the court's jurisdiction in relation to the interpretation and application of the CARICOM Treaty. So every CARICOM country is a member of the CCJ. Every CARICOM country. But there is a second role that the CCJ plays. And that role is when each CARICOM state takes a deliberate decision to alter its constitution so that it no longer sends its final appeals to the Privy Council, and instead it sends those appeals to the Caribbean Court of Justice. Now the strange thing is that all the CARICOM states, except Suriname, Antigua, and Grenada, had solemnly agreed. They signed and ratified a treaty saying that, yes, we will do that. We will stop sending our appeals to England and we will send them to the Caribbean Court of Justice. Suriname didn't sign because Suriname has a different legal system and it wouldn't be easy or even possible in the short run for us to handle Suriname's appeals. Plus, the language is used. They have a different system of law. Grenada and Antigua and Barbuda didn't sign because they recognize that they absolutely require a referendum, and so the government could not commit to something which they wouldn't know whether their people would agree to. And it turned out the people didn't agree to it. But all the other countries, Dominica, St. Lucia, well, Dominica is a member of the federal jurisdiction, St. Lucia, St. Vincent, Kitts and Nevis, Trinidad and Tobago, Jamaica, they all signed and ratified a treaty saying, yes, we will send our appeals to the CCJ. But they haven't done so. Only Barbados, Guyana, Belize, and Dominica send their appeals to the CCJ at this time. So, the way the CCJ functions is just as we replaced CXC, we replaced O-levels and A-levels with CXC and CAPE, so too the idea was to replace the Privy Council with the Caribbean Court of Justice. Because a Caribbean court staffed with the best judges that we could recruit in the Caribbean, whether from the Caribbean or outside, because the CCJ does not only comprise judges from the Caribbean. Currently, there's a judge from England, a very respected judge who is on the CCJ. There's also a judge from, well, he's from the Netherlands, but he was a judge in Netherlands Antilles. He's also on the CCJ. And then there are 4 of us from the Caribbean. And in February, we're going to recruit another judge from the Caribbean. But a Caribbean court staffed with judges who live in the Caribbean, who are for the most part from the Caribbean, will always, my respectful view, be able to give greater effect to our aspirations as a people than judges who live in the United Kingdom and who are from the United Kingdom. Why do I say this? Well, follow me closely because I want to give you a little roundabout answer. The art of judging involves 2 constructs. A judge, and here I speak of any judge, could be a judge at Panorama, a judge of a beauty contest, or a judge in court, any judge. A judge must be able to see from near and to judge from far. Judge needs simultaneously to be near and far. Allow me to explain.
Let's deal first with seeing from there. To be most effective, the judge must be at the front and center of the contest or dispute or the event that is to be judged. And you will notice, whether in a courtroom or at a beauty show or a panorama, who has the best seat in the house? The judge. But seeing from there, and the judge has the best seat in the house because the judge has to see from there. But seeing from there involves more than just where you sit. For a judge sitting in court, judge has the best seat in the house in court too. But seeing from there also involves a cultural nearness. A judge in court should have knowledge of and be immersed in the culture of the people whose disputes the judge is trying. The judge must, so to speak, be on the same page with the people whose dispute the judge is judging. You can't be a judge in Mars and judge a dispute that is happening in the United States. But it is also true, and that is what I mean by you need to be able to see from there. But it's also true that a judge must simultaneously be able to judge from far. And the Privy Council is excellent at that because they are physically, geographically distant. But what I mean by judging from far is not that you must be geographically removed because you're not schizophrenic. You can't be in the middle of the dispute, having the best seat in the house, and at the same time be geographically removed. What I mean by saying that you must be able to judge from far is that you must be detached. You must be able to stand back and not get so personally drawn in that you are improperly influenced by your proximity to what is unfolding. Judging from far involves a mental element of being able to be dispassionate, objective, being able to overcome any biases or prejudice that might influence you to lean for or against any party to the dispute. Judging from far means you must be impartial. And judging from far, as I said, is a state of mind. So, while it is true that physical separation, distance, allows you to be objective in that sense, if you are physically remote, you could never judge from there. And very often you see that coming out from, because the judges of the Privy Council recognize that themselves and they admit it. There was a case of Pandey versus Gordon. This was a case where Mr. Gordon, Ken Gordon, who big entrepreneur in Trinidad, was involved in media. I think he was one of the founders of the Express newspaper, if I'm not mistaken. But he and Mr. Pandey, the former Prime Minister, had a big dispute one time. Mr. Pandey called him a pseudo-racist. Mr. Gordon didn't like it, brought him up in court for defamation. And the judge said, pseudo-racist, that's a very libelous word. How can you call Mr. Gordon a pseudo-racist? I find you liable. And that's a very serious libel. And so you must pay Mr. Gordon $600,000. So Mr. Pandey was upset. He appealed. Said to the Court of Appeals, pseudo-racist is not a defamatory word, a term. But if you found that it is defamatory, $600,000 is too much. Court of Appeals said, no, pseudo-racist is a serious defamatory expression. But we agreed, $600,000 is too much. We will reduce it by half, so you'll pay $300,000. Mr. Pandey was still agreed. He went to the Privy Council. And you know what the Privy Council said? They said, well, on the first issue about whether pseudo-racist is a defamatory expression. So, well, you know, people of the Caribbean are best able to assess whether that in fact carries sting, which Mr. Gordon complains of. And since the courts below, meaning the judge and the Court of Appeal, found that that is a slanderous, a libelous expression, we will not interfere with the judgment in that respect. In other words, they are saying that we are not able to see from there, and therefore that ground of appeal must be. Mr. Pan said, what about the money? $300,000 is still too much. They said, well, you know, money is a funny thing. The value of money is best understood in the society where the money is being used. And therefore, the courts below having found, the Court of Appeal having found that $300,000 is a sufficient sum, then we will not interfere with that either. In other words, we're not able to see from there in order to determine that aspect of your appeal. So he, in effect, had no appeal because the Privy Council judges, and with great respect to them, recognized that they couldn't see from there and therefore couldn't determine a dispute. And so, when we start thinking about whether we should send our appeals to the CCJ or to the Privy Council, one of the things that we need to consider is that not only is a court cited in London comprised, yes, of the best British judges that there are in Britain. I'm not saying they're not good judges, but they're the best British judges for British people. We in the Caribbean need to support the best Caribbean judges for Caribbean people. And for the last 13 years, the CCJ has been dispensing justice for Barbados and Guyana to the satisfaction of the peoples of those countries. You know, I don't mind the referendum results. The people of Grenada and Antigua and Barbuda, they don't interface with the CCJ. They have voted on the basis of their experiences, their daily experiences with their local justice system. And I can understand if it is that when you go to court, your matter is being adjourned again and again and again. If it is that your court is being kept in a building that is inadequate, courtroom is stiflingly hot. If it is that when you go to court, the clerk comes out and says, the judge can't find the file, so we have to adjourn the matter. If it is that you are in custody for 7, 8, 9, 10 years, waiting for your case to be heard, and each of these things happens in the Caribbean, I could speak firsthand to that. If that is your daily experience with the local justice sector, why are you going to vote to get rid of a British institution in order to put instead a Caribbean institution? So that is how people of Antigua and Barbuda and Grenada would think when they voted as they did. Where we have fallen down is we have not done sufficient work to explain to people throughout the Caribbean that the Caribbean Court of Justice is not a part of the local justice system. We don't have any broken down building. We have a wonderful court facility, one of the best that you could see anywhere in the Western Hemisphere. Our case management platform is electronic. I tell you something, how long have that been? On the 11th of May of this year, the Friday before Mother's Day, a litigant in Barbados who wanted to vote in the upcoming elections, then upcoming elections in Barbados, which was going to be held around 18th or the 19th, somewhere around just beyond the middle of May. He had an appeal before us because the government would not register him to vote. He was a solution living in Barbados. He was a lecturer. He had been living in Barbados. He had owned a home in Barbados. And according to the Barbados Constitution and laws, he was entitled to be registered as an elector. But the government of Barbados at the time did not want to register him because there were dozens, perhaps hundreds of other Commonwealth citizens who were in the same position and who you would also have to register. And that government probably felt that all of these people would vote for the opposition because the opposition had a much more favorable disposition towards the CSME and towards its Caribbean neighbors. And so they refused to register this guy. He launched an appeal, he went to the court, he went to the Chief Justice, he went to the High Court, got a decision, he wasn't quite satisfied, he went to the Court of Appeal, he got a decision, he wasn't quite satisfied because none of those decisions compelled supervisor of elections to register him. And so on the Friday afternoon before Mother's Day, he filed his appeal at the appeal came in at 5:20 in the afternoon. Now, as I said, our filing system is electronic. You could be on the beach at midnight and file a case. He was lucky because that afternoon, our registry official, what normally would happen is that because this appeal came in after the close of business hours on a Friday, on Monday morning, it would be formally accepted and then filed and returned to him. But he was lucky in that that week, the filing officers had stayed back to do some work. And so they saw this appeal come in at 5:20. He was doubly lucky because at 5:20 on a Friday afternoon, I should be home in Maryland. But I was in the office. And so they called me and said, this appeal just came in and seems to be urgent. We'll send it to you now. And in seconds, it was on my computer. I looked at it, and yes, it was urgent. And I called the judges, and in minutes, they had it on their computer. It was 509 pages. But you don't need to read all 509. Each of the thing might just be about 15, 20 pages. The appeal was filed. I'll cut the long story short. The appeal was filed. We arranged for Chief Justice in Barbados to make the courtroom available in Barbados so that we could hear the parties electronically by video conference. The appeal was heard on Sunday, Mother's Day. I remember it was Mother's Day because one of our judges is female. And so we excused her from the matter that day. And we heard the matter between 11 o'clock and 1 o'clock on Mother's Day. All the parties were present, all the lawyers were present, everybody had been served with the appeal documents, and we gave an oral judgment a little after 2 o'clock. Now, that was only possible because of the advanced level of technology that the CCJ has. The Privy Council does not have that technology. It doesn't have it. Canada does not have that technology. But you know, few people in the Caribbean recognize that the CCJ has that technology. But the CCJ, you see, the thing is with Caribbean institutions, especially those that replace British institutions, you have to be twice as good in order to be recognized. And sometimes even twice as good is still not enough.
Right.
So, there you are. If we are to advance as a people, then it is important that we recognize those things that are critical for our self-advancement. It can't be logical that we should make our own laws. We elect parliamentarians and we fight and carry on at election time to make sure that our parliamentarian, our representative wins, so that he could go in parliament and make laws. We can't be making our own laws only for British judges sitting in Britain to interpret and apply those laws. That does not make sense. And there's a serious accountability deficit with that paradigm, because one of the important measures of accountability in judging is that the judge must experience the consequences of the decisions the judge makes. If you are judging for a society that you don't visit, that you don't live in, your children don't live there, your mother doesn't live there, your cousin doesn't live there, you are just remote from that society whose cases that you are judging. There's an accountability deficit there. You could do anything. You don't care. You have no consequence. You don't experience any consequence. If we make a bad decision, the newspapers will talk about it. Academics will write about it. There will be a certain social pressure on the decision makers who make bad decisions. But when you live thousands of miles away, there is not that pressure. And to my mind, that is an accountability deficit. One of the arguments that gained a lot of traction in Antigua, as I understand it, is that some of the opponents of the court said, we don't have a problem with the CCJ, no. We don't mind the CCJ. Now, anytime anybody say that, and it's followed by, what? You know something? You know there's something going on. They said, but you can't put a nice, shiny attic on top of a termite-ridden house. Now, that sounds very plausible, and indeed, you would be very foolish to have a termite-ridden house and build a nice shiny attic on top of that. The CCJ is not an attic. If, and I don't agree that the justice system in the Caribbean is a termite-ridden house, but if the justice system in the Caribbean is a termite-ridden house, the CCJ is not an attic on that house. Just as the Privy Council is not an attic on it, the CCJ is not an attic on it. We are a different house. We are a different institution. We are not an organic part of the local justice system where admittedly there are problems. And the curious thing is that having the CCJ as your own final court enables you to help to strengthen the local justice system in a number of ways. It enables you, if you want to use the same analogy, the same disrespectful analogy, it enables you to get rid of some of the termites. And we have been doing that in relation to both Guyana and Barbados. Just the system in Guyana today is far improved from what it was in 2005, partly because of the efforts of the Caribbean Court of Justice. Because one of the tasks of a final court, see, a final court must not just operate as if it were a post office box. That is, you put in an appeal and you get out a result. That is not how final courts operate. The US Supreme Court does not operate in that way. Justice Roberts is the head of the Federal Judicial Academy. In Canada, the Chief Justice of Canada is the head of the National Judicial Institute. The final court has a role to play, quite apart from deciding cases. It has a role to play in ensuring that the local judiciary is run in an efficient way. It has a role to play in ensuring that the judges of the courts at the lower tiers are properly educated, receive judicial education, proper judicial education. The final court has a role to play in ensuring that the justice system is an effective one. And so, the CCJ has, for example, been involved in establishing new procedure rules in Guyana. It has been involved in training Guyanese judges, in training Guyanese court staff, in training Guyanese lawyers, so that you ask any Guyanese, the justice system in Guyana today is much improved from what it was in 2009. In Barbados, after Prime Minister Stewart lost that appeal, he was so upset with us because it meant that a number of Caribbean people were now back up a little bit. When we did that appeal on Mother's Day, we made an order, and because we recognize all sort of nonsense about court and politicians and so on, we recognized what was going on, and we were determined that the rule of law must be upheld. And so on the Sunday we gave an oral decision. On the Monday we issued an order to the chief electoral officer. He said, you register these people, and if you don't register them within the next 2 days, we're going to hold you in contempt of court and send you to prison. And of course, we were registered. So sometimes you will talk about, oh, court, mix up with the politicians and so on and so on. Prime Minister Stewart was so upset with us, and it was in the heat of the Barbados campaign. He went on the radio and he said, we were the first to go in, and we will be the first to come out. Now, you know, we never appreciated how much, we never knew how much the people of Barbados appreciated the CCJ until Prime Minister Stewart had that interview and said those things which I'm sure you got it. because it was a nationwide uproar. The people of Barbados came out and, in no uncertain terms, indicated their support for the CCJ. That for the last 13 years they had every confidence in the court, and then there were the elections following week. Now, it's just coincidence that Prime Minister Stewart not only lost every seat, he lost in every polling station in Barbados except one, Barbados constituency. Now, honestly, that's just coincidence. But there you go, that's what happened. I don't have a problem. I am not worried about referendum results in Grenada and Antigua. Well, what it says to me is that I'm not doing enough public education work. But you see, we have a problem. And the problem is this, that people don't like to see the judges doing that kind of work. Judges must judge. They mustn't be going out there evangelizing and proselytizing. But if the judges don't do it, who's going to do it? CARICOM doesn't have the resources to do it. They have other priorities. No government is going to take it upon itself. So who's going to do it? And that's the dilemma that we face. So, if we are to advance as a people, we need to seriously consider how to make our country more independent and less reliant on Britain. Given our fractured experiences of slavery and colonialism, a paramount virtue which we need to inculcate is self-belief, a clear sense of ourselves, an understanding of our worth as human beings, an appreciation that we're not inferior to anyone, and that we have the capacity to forge our own destiny. If we do that, then I think we'll be doing great service to ourselves, to our children, to our children's children.
Oh, thank you very much. Thank you. I'll check out. That was the president of the Caribbean Court.